Welcome back to our overview of the litigation process in New York, Section 3, post-deposition discovery, IMEs, and summary judgment motions. Post-deposition discovery. This is going to include some expert disclosures, some supplemental records, and after the deposition, if we discover things that we need to follow up on, such as the person made some text messages right after the accident, there were some photos taken from the scene that we didn't know about, or there were witnesses, or there are new medical providers, or new treatment that the person went for, maybe some pre-accident injuries that we discovered for the first time at the deposition, or some post-accident injuries that we discover. Sometimes that happens where they have an accident after the first accident. Also, things in the nature of employment records. These are things that we'll follow up for and get supplemental records. We are on the medical end going to ask for updated HIPAA authorizations, and that's going to allow us to get medical records for things that we didn't already have.
Right. And sometimes we discover at the time of deposition that if they're alleging that they had a shoulder injury, for example, and they went for surgery, we discover at that time that they're alleging that now there was a complication from that surgery, and they're trying to attribute that to the accident that we're here there for.
Mhm.
At that time, we want those medical records for sure. So we're going to issue those post EBT demands for those records. Sometimes they'll start claiming other injuries, residual injuries that they're trying to create a nexus between those injuries and the accident.
Yeah.
And we definitely want those records. Or like you said, employment records, sometimes if the BP doesn't illustrate that there's a lost earnings claim,
Mhm.
we will either want the attorney to state on the record that there is none, or if they refuse to do so, we demand in writing, obviously, we demand for them to update and send us a supplemental BP illustrating that there was time that was lost from work.
And the time frame for these post-deposition demands are usually set forth in a court order, some type of a discovery order. The order will enumerate depositions to be held by, post-deposition demands to be served by, responses to be provided by. And then they're also going to give us IME dates, which we're going to get into next. And the expert disclosures, once we decide what IME doctor we'd like to go with, we provide what's called, which we refer to it as the 3101D. That's the CPLR section that it falls under. We call it 3101, a 3101D, an expert exchange. These are all synonyms for that type of discovery exchange. So the post-deposition discovery, it's basically us or the plaintiff asking questions that are follow-up questions. We get them sometimes and need to respond if our client, as the defendant, makes a statement or says, "Oh, I was on the phone at the time." They might want those phone records. If he says, "Oh, well, I was working," all of these things are legitimate requests to be asking for in post-deposition discovery demands. We we generally don't object, but if we do want to object, then we would have to make a motion saying for what they call a protective order, because the plaintiff's discovery demands might be so broad or asking irrelevant questions, like what was the guy, when did the guy get divorced, or what was the settlement like when he got divorced the first time? I mean, obviously that's not relevant to a rear end accident. So something like that, we would have to make a motion for a protective order telling the judge, we're not going to give them this because it's not relevant. We try to avoid that type of motion practice because it just prolongs the exchange, and the motion practice in general can drag things out a little bit because of adjournments and court dates.
And usually the court will require a good faith affirmation on those discovery motions to basically state to the court that we've tried to work this out attorney to attorney without getting the court involved. And we're at odds with one another and we're at an impasse. So that's why we have to make the motion. But sometimes we're able to just work that out between attorneys.
Yeah, and the good faith letter is for both post any kind of discovery motion, let's say. For there's a
Mhm.
discovery motion, a good faith affirmation means that we tried. We contacted the plaintiff, we asked them, we emailed them saying, please give us this information. We sent them a letter and they ignored us. That's the good faith effort, and that goes into an affirmation as part of the motion. So a motion to compel or preclude will have your notice of motion. It will include your good faith affirmation, and then an affirmation and support from the attorney with all the relevant exhibits that we need to show the court. Next, after that's completed, or sometimes the post-deposition written discovery can be done almost simultaneously, we move into our IMEs, or independent medical examinations. These are typically held 30 to 45 days after the deposition. The key words here are designate and held by. Designate means we have to appoint a doctor and schedule it. The adjuster's role is to, first of all, give us, the defense counsel, authority. And we often like to discuss with the adjuster the doctor that we're choosing. Their best practices for insurance carriers, most of the time they will have approved list of vendors. These are third-party vendors that go ahead and schedule the IMEs, send us a list of doctors on their panel, and we'll go through and pick a doctor. If we have a particular doctor from a specialty that we like or who's a good expert, we will request them to do the IME. And the adjuster's roles, keep an eye on it, make sure it's getting scheduled properly, make sure they give us authorization, track when it's supposed to be held, and reporting. Again, these aren't your responsibilities, so to speak, as an adjuster. Your attorney should be giving you this information. But if somebody asks in your office or you're in a meeting, when's the IME going to be held? You want to know that information.
And usually those conversations revolve around, in addition to who we think should be chosen for a particular IME, the cost benefit analysis. A lot of these doctors, well, first of all, obviously the adjusters know this, that independent medical examinations are a lot of money. And that's from the examination itself, that's from the doctor reviewing the records, that's from then generating the report that follows, and possible testimony down the line. Depending on the case and the dollar amount on the case, as well as the injuries, sometimes, of course, with liability concerns, we don't always want to spend so much money on a particular doctor. Sometimes the record review costs different from doctor to doctor. These amounts vary.
Mhm.
And if we're spending these resources, that conversation definitely revolves around this cost of benefit analysis,
Yeah.
right, Mike? Do you agree with that?
Yeah, absolutely. We're always cost conscious. I mean, at the end of the day, to defend these cases, we not only want to do an excellent job, but we want to keep costs down and keep the life cycle of the case as quickly as possible to resolution.
Right.
Typical specialties, orthopedics, neurologists, PM&R, which is a pain management and rehabilitation, you got chiropractors and acupuncturists, psychologists, less frequently, but they do occur, and then the neuropsych evals. The IMEs typically take anywhere from, an hour to 2 hours. A neuropsych can take up to 8 hours. The plaintiff's bar definitely has a list of plaintiff's attorneys, of plaintiff's of doctors that they know how to cross-examine. So we're very selective because some of them are just known. I won't name any names, but there are some IME doctors where a plaintiff sees that doctor and they're like, oh, like I got this guy. They know exactly what to cross-examine them on. So we
And
try to,
we're aware of that too, right? We're
yeah, of
aware of that
course.
as well. We
Absolutely.
know that this is a pressured environment, that plaintiffs' attorneys, especially the good ones, know how to ask the right questions,
Mhm.
know how to get a doctor nervous or hope to get a doctor nervous.
Yep.
And we know which doctors testify well in certain conditions. And so that goes into our analysis as well.
Yep. If they miss an IME, we make a motion to compel or preclude. Again, the motion to compel is asking the judge to force them to appear for the examination. Usually, if they miss it, we're asking the judge to preclude them from offering testimony on damages because we weren't able to conduct our IME. That's a difficult threshold for us to meet, but sometimes they do blow them off. I know, Christina, you just had a case the other day, like it was last week, where we made a motion to compel because the
Yeah.
person missed, I think it was 2 or 3 IMEs, and our client had to pay for those no-shows, and they were expensive. And
Yeah.
as soon as we filed the motion, the plaintiff's attorney was like, "Oh, wait, my dog ate the homework."
Right. Still appear. But actually, he sent us a stipulation trying to just resolve that motion in the form of a stipulation.
Hmm.
And we refused to sign the stipulation. We want the court to hear that motion and make their decision. If we had signed that stipulation, that's basically throwing our motion out the window because in that stipulation, would have been agreeing to setting them up for another IME.
Right.
So these are also, again, not to say that it was intentionally sneaky, but sometimes the better plaintiffs' attorneys or the better attorneys in general, they will do these types of make these moves and there's tactics there. They know what they're doing. So you have to be careful and pay attention to each particular case and what stage you're at before you sign your name to anything, really.
Mhm. Yep. So with post deposition, we did our written discovery after we have everything we need. Plaintiff went for their IME, everything went smooth. The IME scheduling wise is very similar to a deposition where we coordinate with the vendors. The vendors send out the letters. We'll get the report back from the IME doctor after it's held. We, as the attorneys, then take that report. We write a report on that report, send the report and our report to the adjuster. And our defense reports generally include some type of recommendation or the further defense strategy and the next steps coming up for the case so that we can be prepared to move forward to the next stage. And of course, we discuss summary judgment motions at that point in time. The IME, this summary judgment motion based upon the IME would be what we call a threshold motion. That means that there was no serious injury. The insurance law and under the statute, there is a section where it enumerates and identifies what a serious injury is, such as a broken bone. A herniated disc can be a serious injury. The loss or use of a body function or system, that's considered a serious injury. A herniated disc that healed in 6 to 8 weeks is not. Soft tissue injuries, sprains, things of that nature usually will not meet the threshold. This is a well settled area of law, really boils down to the facts and the IME and the medical records. What us coming across an issue where to a particular injury, is it or is it not a serious injury? We usually know going in what those results are going to be. The threshold motion will generally contain admissible proof, not generally, has to contain admissible proof, and that's the IME doctor will usually affirm or notarize the IME report itself. Liability motions are who's at fault. If we are the defendant and our defendant rear-ended the plaintiff's going to make a motion for summary judgment on liability. And they're going to say the deposition transcripts are clear. My client says they were hit in the rear. The defendant says, yes, I couldn't stop in time. There are defenses to that type of a rear end motion, which we can go into more detail with in a different section, such as a sudden surprise or a tire flew in front of the car, so the plaintiff had to stop short, and then the defendant hit them. There are certain instances where we can defend that type of emotion. Liability motions, side swipes, who's at fault. These are our job as defense counsel is to show the court that there are actually questions of fact that need to be determined by a jury. Because a summary judgment motion in general is saying, Judge, based upon my papers and everything you have in front of you, all of this admissible proof, it shows that my client was not liable based upon the law. There is no factual issue. The facts have
Right.
been determined already. It's
There's
our
only
job to let
one
the
clear
judge.
result, right? One clear result.
That's right. And
And
it's our
so,
job to say, no, there's a question of fact as to whether or not, this particular accident happened the way that it did. And this needs to go before a trier of fact, which is either a jury or a judge or an arbitrator or something of that nature.
or ask the court to not consider certain pieces of evidence that plaintiff is putting forward, such as an uncertified police report. And so the court sometimes, based on
Right.
on those evidentiary issues, we can get out of it as well, or be successful in our
Right.
opposition.
We do have to follow the rules of evidence. We refer to them in our motion papers or, in court on these motions as proof. It's admissible proof. Evidence really comes in at trial. A piece of document goes into evidence at trial, not at generally not summary judgment motion stage. That's admissible proof in the form of affidavits and other forms of admissible proof. But the IME doctor will look at the medical records, and the plaintiff will put in some medical records on these threshold motions. Liability motions, it's generally the transcript or an affidavit from a witness or from a party. When we oppose a summary judgment motion on liability, we do want a response, an admissible proof from our client, from the actual person, some type of an affidavit or a contradictory testimony. We do want to have something from our insured, so cooperation becomes important. The timing, before or after the note of issue, but before trial, obviously. Anytime before the note of issue, a summary judgment motion can be made. Sometimes it won't be ripe. We've had those. We've defended. Plaintiff made a motion for summary judgment after the plaintiff's deposition, but not before the defendant's. And our position in opposition is this is premature. Discovery is not complete. Our client didn't perform a deposition yet. So oftentimes a judge will deny those as being premature. If after the note of issue, which is the notice of trial, the judge, usually the court part, will have a time frame for us to comply with. Most often in Supreme Court, it's about 60 days. It can be from 60 up to the statutory 120 days. Civil courts, there usually are no preliminary discovery orders, so you do get the 120 days within which to make the motion. We don't like to wait that long. That's a long time. That's 4 months. So if a note of issue gets served, and then we're going to wait until the last minute, and then that motion is going to be adjourned once or twice. We don't want it to be a year down the road before this motion gets heard. So we want to be on top of it. If we're going to make these motions, we're going to do it right away. Any other points you want to make? I think we just about concluded this section of our deposition discovery.
I think just what you said, at this stage, we always explore, even on our end, the possibility of motions, right? So we're looking, obviously we're looking to save cost, but we are looking for even summary judgment motions on the issue of liability on our end too, right?
Yes, of
Sometimes
course.
a plaintiff will walk themselves into something that now the plaintiff's attorney has their head in their hands,
Yes.
shaking their head because based on deposition testimony, plaintiff is now basically admitting that they're liable. So we always explore that. We don't want to miss that window. If the note of issue is filed, we usually roundtable it on our end and just say, okay, any dispositive motions need to get filed at this point. And that's basically or generally a team decision.
Mhm.
Again, we update the adjuster with another report. And so
We
everyone's
have seen where we're the defendant, and then we get through the depositions, and it's discovered that it wasn't our client's fault at all. It was actually the plaintiff, and the plaintiff just sued first, basically.
right,
That
right,
happens a lot.
right.
That happens a lot.
Yep.
Of course, at this stage too, we're keeping an eye out for fraud and things of that nature all the time. But that's takes us through now in this litigation process from the summons and complaint all the way through discovery. We did depositions, we did our IMEs, we made of all of our motions. Case is still around, all the motions were denied, and now the next stage for us is going to be making that decision on whether or not we want to try this case. So we'll go into the trials, which will be a brief overview of the trial process, and we'll be right back.